It's a great honor for me to introduce our first presenter today, Professor William Schabas. William Schabas is a professor of international law at Middlesex University in London. He is also a professor emeritus in international human rights law and human rights at Leiden University, professor emeritus of human rights law at the University of Galway, and an invited visiting scholar at the Paris School of International Affairs. Professor Schabas is recognized as a leading expert on international human rights law, international criminal law, genocide, and capital punishment. Today, Professor Schabas will be speaking on the article that he authored entitled Legal Opinion on War Crimes Related to the United States Occupation of the Hawaiian Kingdom since 17th of January 1893, which is published in Volume 3 of the Hawaiian Journal of Law and Politics and also in the Royal Commission of Inquiry book that is here today. Please join me in welcoming Professor William Schabas.
Distinguished participants, colleagues, dear friends, I feel very honored to be invited to make this presentation to you here. I was approached, I think, 4 years ago, 3 or 4 years ago now, by Dr. Sai about preparing an expert opinion for the Royal Commission on the subject of war crimes. It's premised on the assumption that the Hawaiian Kingdom remains to this day in a state of belligerent occupation by the government of the United States. And it's an attempt to examine the consequences of that occupation in terms of liability for what are called war crimes. And so I'm going to go through some of this. Please excuse me if it sounds occasionally a bit pedantic or professorial. It's my profession, and I can't really get through this material without a bit of that. And I hope that I'll make the material, which can be quite technical and legalistic, accessible to all of you. And of course, we'll have a question period as well if there are aspects and issues that remain unclear for you. The body of law I'm going to talk about, we're within the general framework of what we call public international law, but it has different features and different components to it. So the first, which is, these are all related bodies of law, is the law dealing with the use of force. And we've all heard lots about that in the last 11 months since the conflict between Russia and Ukraine began. This all relates to this issue of the prohibition of aggression and the prohibition of annexation. The second body of law that's important is what we call the law of armed conflict. Earlier, there was reference to international humanitarian law. These are synonyms. They mean the same. If you learn your international humanitarian law in the military, they'll call it the law of armed conflict. If you learn it in the university, we call it international humanitarian law. This is the law that governs the conduct of a war and the treatment of persons who've fallen under the control of one of the parties to the conflict. That's the part that concerns us. We're not here talking about the conduct of hostilities in a war. We're talking essentially about the treatment of peoples in an occupied territory. And that means that we don't need the presence of an armed conflict. The occupied territory results from an act of armed conflict, but the situation of occupation may continue for many years after the Hawaiian Kingdom being, in a way, the supreme example. But we have other more modern cases, and I'll speak about them a little bit because they're relevant to the issue, and they are also useful in conveying to a broader public around the world the importance of the issue of occupation. I'm speaking, for example, about Palestine, occupied since 1967, Northern Cyprus, occupied since 1974, not as long as the Hawaiian Kingdom, but an awfully long time, generations for the people of those countries. We have the example that gets all of the attention and the publicity today are the occupied portions of Ukraine, Crimea and the Donbass. So a topical issue, one of great concern, and in many ways provides an opportunity to convey and to explain to people about this, in a way, the oldest, as it's been said, and the most enduring situation of belligerent occupation. The third area of law, which is related, relevant to this, is human rights law. I'll say less about this because I'm really focused on the war crimes, but the war crimes are closely related to ongoing violations of human rights, and we have a body of law that has developed since the Second World War that we call international human rights law, and that, like the other bodies of law, are binding on the United States of America, as well as on, of course, your neighbors in all directions, countries around the world. And then finally, the field that really is my field more particularly, which we call international criminal law, that applies here in Hawaii, as it does elsewhere in the United States and other countries, the domestic criminal law dealing with what we tend to call ordinary crimes, and then the international crimes, which are subjects of international interest. Ordinary crimes are, in principle, the property of a sovereign state, and no other country really is interested in dealing with them. International crimes, on the other hand, create special obligations and instruments as well in terms of prosecuting them. And so when it's a case of international crimes, we have institutions that deal with them as well. The most famous of them all today is the International Criminal Court. The most famous of them historically are the two that we call in colloquially the Nuremberg Tribunal and the Tokyo Tribunal, after the cities where the trials took place. The title of my report is War Crimes. I need to say a word of explanation about this because war crimes have, the term has different meanings. There's a technical meaning, which is the one that we apply in the courts, the field of international criminal law. There's more of a colloquial meaning as well. When I speak, maybe later today, well, it's too late in the time zone, but tomorrow morning I'll talk to my mother in Canada and she'll ask me, what were you doing? And I'll say, well, I was talking about war crimes in Hawaii. I'm not going to say to her, I was talking about war crimes, crimes against humanity, genocide, and the crime of aggression. It's enough for me to say war crimes, and I have a little clipping up there to give you an example of it. This is from the New York Times a few years ago. A Bosnian Serb who had been convicted by an international criminal court, the International Criminal Tribunal for the former Yugoslavia, and the headline in the New York Times says, Momcilo Krajnik, Bosnian Serb, convicted of war crimes, dies at 75. It's not accurate. He wasn't convicted of war crimes. He was convicted of crimes against humanity. But this is a nuance. This is being pedantic a little bit. And it's the use of the term in the colloquial sense, the way I would use it when I'm talking with my mother. But the report I've done for the Royal Commission is different. It's about the technical term of war crimes, which are certain specific violations of the laws and customs of war, of the law of armed conflict, of international humanitarian law. And I've mentioned here two of the classic places that we look for these war crimes. One of them are, we have this notion of serious violations of the laws and customs of war. So not all violations of the laws and customs of war are war crimes. They're violations of the laws and customs of war. They may be addressed in some legal context, but we're looking at a narrower subset that have been identified as serious violations and therefore as war crimes. And that elevates them into this field of international criminal law. They are international crimes subject to prosecution by international tribunals, as well as by the courts of countries around the world that may have no direct interest in the place where the crime was committed, but are entitled to prosecute them under the principle we call universal jurisdiction, because they are crimes of concern to the international community as a whole. And today, the prevailing definition of war crimes, where they're actually codified, set out in print as to what they are, is Article 8 of the Rome Statute of the International Criminal Court. The Rome Statute has not been ratified by the United States of America. The statute was signed by the United States of America, which is more of a symbolic act of favorable disposition towards the text. This was done in the dying days of the Clinton administration at the end of the year 2000, and then it was repudiated and revoked, the signature, a few years later, and the United States of America has run hot and cold over the years in terms of its approach and attitude to the International Criminal Court, mainly depending on whether the International Criminal Court shows any interest in prosecuting crimes with which the United States may be associated, or crimes with which the allies and friends of the United States may be associated, and crimes with which enemies of the United States may be associated. And as long as the International Criminal Court goes after the enemies of the United States, it is quite friendly to the institution. And when it starts to nip at the heels of the friends of the United States or of the United States itself, it releases its venom and hostility to the organization. Something's happened to my screen. I think it's telling me I talk too long when I'm looking at a slide. It's a message to move on. So this slide tries to enumerate some of the sources of the law specifically when we're talking about war crimes law. I should say as well, because I've referred to other areas of law, this is the time factor is extremely important and interesting to us, because on the one hand, we need to determine the law that was in force in the 1890s for obvious reasons. But of course, we also need to determine the law that's in force today. And we also need to establish how much of this law applied to the United States of America and identify parts of the law that maybe don't apply to the United States of America, because international law is a mixture of rules that apply to every country and then rules that apply particularly between different countries as a result, in general, of treaties that they've made on a bilateral or a multilateral basis, or on customary law, which may be regional in nature, just as it may be universal in nature. The other thing that is so important in doing this is appreciating how the law has evolved and developed. And we'll see when it comes to looking at the specific war crimes, when we study that field, there are acts that were committed in the 19th century, in the 1890s, that were not then considered to be war crimes, but that are today. Just as there are acts that were prohibited and were treated as prohibitions, maybe war crimes in the 1890s, and that seem to be accepted today. I'll give you a couple of examples. Today, we say that it's prohibited to conscript, recruit, and actively use children in armed conflict. But if we're talking about a 14-year-old, there's no doubt this is an international crime. It wasn't 125 years ago. It wasn't even prohibited 125 years ago, and armies had many adolescents, teenagers who were part of their armies. So this is an example of a crime that has become an international crime since then, but wasn't in the 1890s. But to give another example of a prohibition that went in the other direction, at the end of the 1890s, at the famous Hague Conference of 1899, a treaty was adopted prohibiting the use of aerial bombing in armed conflict. Can you imagine how much happier humanity would have been if that prohibition had continued? It didn't last. And of course, today, it's an accepted fact that wars involve dropping bombs out of airplanes and drones and so on, when 125 years ago, this was actually prohibited. So this is crimes. What were the war crimes? And then finally, one other thing is that the occupation of the Hawaiian Kingdom removes it from participation in the making of international law. And that's also of relevance to our conversation. Because the law really is developing it's almost a turning point, the 1890s and the beginning of the 20th century, in terms of the law as it is advancing and developing. The notion of war crimes is entirely new. And in fact, there's no basis for prosecuting war crimes until we get to the end of the First World War in 1919 and the conference in Paris, the Paris Peace Conference, where the notion of war crimes was developed. Prior to that, we had these important treaties, and they're referred to in our materials, the Hague Conferences of 1899 and of 1907. But the Hawaiian Kingdom, for obvious reasons, was not invited to those conferences. We were talking about it, Dr. Tsai and the others yesterday, and saying that had the occupation not taken place and had the annexation not taken place, probably the Hawaiian Kingdom would have been invited to the conference in The Hague in 1899 to participate in the making of international law. There was a subsequent conference. The one in 1899 was convened by the Russian Emperor. The one in 1907 was convened by the American President, Theodore Roosevelt. I'm not so sure about 1899, actually, whether the Hawaiian Kingdom would have been invited, even if it was not occupied. Not every country was invited. So this list is important. It develops following the trials at the end of the Second World War, the Nuremberg trial, and the Tokyo trial. And it's only at that point that we really develop treaties where these crimes are identified. The Geneva Convention of 1949, there are 4 of them. There's one that interests us. This is the 4th Geneva Convention, because the 4th Geneva Convention deals largely with occupied territory, and it's the gold standard. And the 4th Geneva Convention underwent some development, became more detailed and sophisticated in a protocol that was adopted to the Geneva Convention in 1977. In terms of these bodies of law, the position of the United States of America, it participated in the Paris Peace Conference, and there's no, I think, serious argument that it wasn't in agreement with the list of crimes that was developed there. American judges at Nuremberg referred to the list in their judgments in the post-Second World War period. The United States, of course, is a party to the 4th Geneva Convention, but not to the additional protocol to the 4th Geneva Convention. And finally, in the modern period, we have tribunals with which the United States is associated, although it's not subject to them, the ad hoc tribunals created for the former Yugoslavia and for Rwanda, and then the International Criminal Court. People sometimes think because today the United States is not necessarily friendly to the International Criminal Court that it's hostile to international justice. But it loves international tribunals when it controls them. And that was the case with Nuremberg and Tokyo, and more recently with Yugoslavia and Rwanda. Very great enthusiasm, great support for it, but as long as it wasn't possible for it also to be within the sights of the tribunal. I mentioned the time factor. This is important. This is we can't escape this. This is about when crimes took place, whether they were viewed as crimes. So I've put up here on the screen a quotation. It's not directly relevant, I think, to the situation that we're considering here. This is from a document that was adopted at a great conference organized by the United Nations in 2001 on racism and racial discrimination. Virtually every country in the world participated, and virtually every country in the world agreed with the declaration that was adopted at the end of the conference. 2 countries boycotted the conference, Israel and the United States. And I have to tell you, because I've recently done a study of this, basically every significant attempt by the United Nations since 1945 to deal with racial discrimination, the US government has found one reason or another, one pretext or another to say, we're not going, we're not part of it, we're avoiding it. And that continues to the present day. The declaration was adopted at the Durban conference, nevertheless had controversies in it, and they were able to agree by what we call consensus to a text, but then states would append declarations saying they disagreed. And so here the declaration talks about slavery and the slave trade, and it says that they are a crime against humanity and should always have been so. And this is very controversial language because the countries of the Caribbean and the countries of Africa both made statements when this was adopted saying, we don't agree. We don't agree that it should always have been so. It always was. And so this is important to understand because we're going to encounter similar arguments when we talk about war crimes in the 1890s and in subsequent years, that at the time they should have been a war crime but weren't recognized as a war crime. It's a period that's very much a hinge period in the development of the law because we don't really have a recognition of war crimes in a formal sense until the Paris Peace Conference in 1919. And it's important to be able to say that some of these acts and crimes were in fact crimes back in the 1890s and in the years that followed. I've also used this word decolonizing. I want to be clear, I'm not suggesting that we're talking about a colonial situation. I understand that's not the reality. We use the term decolonizing much more generally in international law to refer to attempts by many participants, scholars, activists, and so on, to view international law differently, not as a creation of powerful states in the global north, but countries in the global south who use international law as a battleground to advance their ideas and their positions and to deal with historic injustices. And we use this term intertemporality sometimes, and that too is a confused term. The notion of intertemporality, which was developed in the context of a dispute between 2 colonizing nations from Europe who were quarreling over an island, who had the island, and what was the law that was applicable. And this was at a time when they considered the law was being made by a handful of European colonial states, and the rest of the world didn't participate in it. So one of the problems is sometimes the law we want to uphold, and the hypocritical states who helped develop it, who participated in the process, find ways to defy or to ignore the law. And so it's important to use the ancient law and hold them to it and say, you're applying double standards, you're not respecting the law. But in certain contexts, it's also important to remind people that the law was created at a time when many parts of the world didn't participate in making international law, and there's no reason, therefore, why they should be bound by it and why they should be required to follow it. So this is kind of the paradox that we have to encounter in examining this question as well. And finally, an example. This is not about war crimes. This is a cartoon from the International New York Times some years ago. And of course, it deals with the Armenian genocide and the Ottoman agent who's standing there herding the Armenians onto the railway cars is saying, don't worry, the word genocide doesn't exist. So I'm making this point because don't worry. The fact that war crimes were not defined by treaty in the 1890s and in the beginning of the 20th century doesn't mean they didn't exist. One final point about this, because I'm going to go and talk about some of the specific war crimes for a few minutes, is that we're not talking, when we debate about whether genocide was committed, the operative date for the Armenians in the Ottoman Empire is 1915. There's no realistic hope that we're going to prosecute any individual for those crimes in 1915. There are no perpetrators left alive. Nevertheless, the debate about whether these were war crimes remains salient. It's extremely important because we're using this term and this notion of war crimes. Of course, we would like to get people into criminal court, charged with them, and have trials and prosecutions. But there's also more of a rhetorical use of the term, which is extremely important. It underscores the gravity of the acts, that they are treated as crimes. And so that international historic dimension is also of great importance to us. This is another facet of the time factor. So I talked about intertemporality a minute ago, the idea that we apply the law based on the law as it was when the act in question happened, rather than the law as it is today. But we also have this problem when we talk about criminal prosecution. People say you can't prosecute people retroactively. And we all understand you don't have to be a lawyer to know that principle. I saw that the lawyers for Alec Baldwin, the actor, are raising that argument in court with regard to the recent charges that have been made against him, saying it's a headline in the newspaper yesterday or the day before, saying the prosecutors made a mistake because the prosecutor's charging a crime that wasn't a crime when the act took place. That's the idea. It was raised by the defendants at Nuremberg. It was raised by the defendants at Tokyo, and it gets raised again. And it gets raised basically in any discussion where you're talking about prosecuting crimes where the acts weren't necessarily defined by a treaty or in a code, but where they were nevertheless prohibited. And the law recognizes this. The Nuremberg Tribunal recognizes it. And I've cited here a case that won't be familiar to most of you, I'm sure. This is from the European Court of Human Rights, dealing with a retroactive prosecution of war crimes in the Second World War. And I had the honor to be counsel to Latvia in that case before the Grand Chamber of the European Court of Human Rights, where we won the argument that certain acts that were not set down in black letter law when they took place during the Second World War were nevertheless war crimes, and it was entirely legitimate to prosecute them in modern times. So this is the first of our crimes that interests us: usurpation of sovereignty during occupation. This crime is on the list of 1919. It's not in the modern codifications, and that means, and I mentioned this in the legal opinion, maybe I a little bit. I think I might just fine-tune the phrases if I was to rewrite it again, the opinion. But it's an issue that we'll have to confront in the debates. People will say, well, okay, that was 1919, but why hasn't it been continued into modern times? And there may be different explanations for that. It was certainly referred to, this crime, in 1940, in the aftermath of the Second World War, before the American military tribunals that sat in the Nuremberg courtroom. And this is from the trial. Some of you may know this. This is the trial on which the film Judgment at Nuremberg, the famous film, is based. This was the trial of Nazi judges and prosecutors. And the issue arose about that crime, and the American judge referred to it in the judgment, the crime of usurpation of sovereignty. And there were discussions of it in 1919 as well. And but I'll let Keanu do he's done this and demonstrated it in his writings as well, how the facts fit that crime, the facts of the destruction of institutions, the replacement of institutions by the occupying power. The legal question that's of interest here is how to position the crime as a continuing crime or as a crime, because we have some crimes that start, they're committed, and then they continue. The crime of apartheid is a continuing crime. We don't say that the crime of apartheid takes place when the legislation is adopted. The crime continues as long as that legislation is in force. And I think the same must be true of the crime of usurping sovereignty in an occupied territory. It's very clear this prohibition was discussed and taken as an important prohibition in 1919. It's referred to in 1945, and I think this is where we have to, where the arguments have to be made based on the facts. So I can, you know the facts. I can deliver the law to you. I think they line up. I think that this crime, and I'm anxious to see it picked up, the two cases I've mentioned here. As I say, we can add Crimea to the list, but the ones that are protracted and extremely painful crimes that I've been involved in are the cases of occupation both in Cyprus and in Palestine, which are ongoing situations of intolerable occupation. The second crime, denationalization. This too is on the list in 1919. I think that it has been, it's not in the modern day codifications. It was referred to in the Nuremberg trials, but it has been overtaken, I think, by two other crimes that cover much of the same reality, which are crimes against humanity and genocide. Genocide in its most extreme form. Genocide is more narrow because it requires really physical extermination of a group. And the thing about denationalization is that it's much broader, and it includes what we often call cultural genocide, the destruction of a culture, the destruction of the language, as a way of removing the group, because you can destroy a group, a national, ethnic, racial group. You can destroy that group by other means than physical extermination if you remove all of the features of its cultural identity. And that's what that crime captures. And finally, I have some other crimes there on subsequent slides, but I think my sell-by date has arrived. I've talked enough. There are details there about pillage and military recruitment, and they're of secondary interest. You can read about them in the report. But I'll conclude with this one, population transfer. The transfer of a population into an occupied territory. And this is, in a way, the interest in this crime is that it's covered by the Geneva Conventions. It's in the Fourth Geneva Convention, the prohibition of the transfer of settlers into an occupied territory, and it's set out as an international crime in the first additional protocol to the Geneva Conventions adopted in 1977. So it has the strongest claim to be an international crime in the present day. And so the transfer of your population into an occupied territory is prohibited. And it's prohibited because of the consequences that you all know, that it transforms the demographics of the population and may ultimately lead then to the destruction of the reality of the territory, the social and cultural reality of the territory over time and indirectly. And we have manifestations of this elsewhere in Palestine, where the population of occupied Palestine has been transformed by settlers moving into Palestine, and to some extent in northern Cyprus, although northern Cyprus is different because it involved the expulsion of the Greek-speaking indigenous population of northern Cyprus. So these three crimes, these three core crimes, the usurpation of sovereignty, the transfer of populations, and denationalization are all real crimes, crimes where there are good arguments, strong arguments for their international dimension as crimes under international law, and where the definitions find very clear application, I think, here in the occupied Hawaiian Kingdom. Thank you for your attention.